Well, tonight we are talking about Meet the Judge-elect, Adrian Powell, who's with us tonight. And Adrian, we have Sue from McCalla, who's been hanging on the line patiently for us. Sue, we really appreciate that. Go right ahead with your question, if you will.
Good afternoon. Yes, I have a question. When is the child ever have any? How do they have to be? We have a child situation that one parent has not been in the picture at all. They come in and out like at holidays and wants to see him. The child screams and cries, don't want to go. We've had full custody, never done anything, took us back to court trying to get full custody. She didn't do what the judge told her to do, and but he gave her full visitation rights, like every other weekend she gets to go see him, and the child still screams and cries and don't want to go. So when are they ever going to let the child have any decision?
Right, I understand exactly what you're saying, and that's also a great question. I get those questions quite a bit. So a lot of people think that there is an actual time frame, an age where a child can go in and say that they do not want to go on a visitation with the parent, or if there's court order visitation in place, that child can say that they do not want to go. What the court does is, let's say that there's not a visitation schedule in place, and the party that is trying to exercise or trying to get visits has not been around the child. The court does take into consideration what that child wants to do depending on their age. So they look at the maturity of the child. So if you have a child that's 16 and they're saying, hey, I don't really want to go with this parent or something of that nature, the court does take that into consideration. They do that as well when it comes to custody. But that parent will be allowed to have some type of visitation. Unfortunately, you do have a situation where a child may not want to go. The court is not going to hold that parent that has custody, that has a visitation schedule in place. The court is not going to hold them in contempt if they are, as long as they're not interfering with that visitation, meaning that they're not telling a child that they don't have to go or something of that nature. So that particular parent will be able to exercise that visitation even if the child does not want to go, just as long as the parent that has custody does not interfere. But once they get a certain age, the court is not expecting that custodial parent to drag this child at 16 out of the house and force a visitation with that other parent. But the court has in the past said, if you are able to get this child to cooperate and go to school, then you should be able to assist and get that child to cooperate and go with that particular parent. However, again, if it comes to a point that the court realizes that this is starting to take effect on that child, there's some type of mental issues that are affecting the child as they go on this visitation, then you can always go back to court and ask for a modification. Ask the court through a petition if you can amend that visitation. Maybe it needs to be less time. Maybe there needs to be some counseling. Maybe there needs to be something that's put in place so that they can restore whatever that relationship or see what the issue is of why that child does not want to go. Could be because they're not used to being around that particular parent. So things and measures can be put in place, but it's not a time frame that it stops. That parent does get visitation.
Wow, that's a great question and a great answer. Thank you so much, Sue, for helping just to educate us on that process there.